Welcome to Module number 5. It's not just about HIPAA. If you are having trouble accessing any of these modules, contact the Chief Privacy Officer at privacy@uvm.edu or call the Office of Audit, Compliance, and Privacy Services at 802-656-3086. Otherwise, let's begin. In addition to the privacy rule, there are other state, federal, and international laws and regulations that may also cover research data. There are Department of Health and Human Services regulations for protecting human subjects. As mentioned in a previous module, there is FERPA that covers education records. In addition to these, there is also the Gramm-Leach-Bliley Act, or GLBA, that requires us to safeguard financial information. And then there's the European Union's General Data Protection Regulations, or GDPR, that puts certain requirements on how we handle personal data on EU data subjects. While there is no single federal privacy law in the United States, each state has their own laws. What's important to note here is that most state laws are not triggered based on where the information was collected or housed. Most state laws are triggered based on where the individual resides. That means that if a violation occurred at UVM, but the data included residents from 28 states, we would need to comply with 28 different state laws, all of which are nuanced, and some of which require that we report to state agencies, such as attorneys general, and some to law enforcement agencies. In general, when the privacy rule and state law have requirements related to the privacy of health information, the privacy rule will override the state. Those requirements not contrary to a provision in the privacy rule remain in full force and effect, so that covered entities will continue to have to follow such state laws in addition to the privacy rule, unless an exception applies. If the state law is both contrary to and more stringent than the privacy rule, covered entities are required to comply with the state law. For example, many states, Vermont included, have requirements such as those related to reporting of disease or injury, child or vulnerable adult abuse, reporting of birth or death, or for conducting public health surveillance, investigation, and intervention. In these cases, the reporting requirements are not overridden by the privacy rule, so state law will apply. Understandably so, this may be very confusing for researchers. The best way to look at the data that you are using for your research is that if it can be tied to an individual, it is likely protected. If not under HIPAA, then under some other regulations such as FERPA, GLBA, GDPR, or other human subject protections which are detailed in the next module. Best practice is that even if it's not protected under HIPAA, treat it as though it is, and you won't go wrong. You have now reached the end of module number 5. If you are taking this training as part of a requirement, you will have to answer questions in order to move on. Next up is module number 6. What about other human subject protections?